Welcome back, everyone, to our art law discussions with Dr. Kyle Layden from the Courtauld Institute and Stephen Coopersmith, founder of the Coopersmith Law Firm in San Diego, which, among other, specializes in art law. And today we begin by talking about provenance, title, and the challenges thrown up by multi-jurisdictional context, that is, important issues relating to ownership of works of art. Steve, I'd like to start with you. Your guide notes that, quote, just because an ownership history has been traced, it does not imply there is clear title. Could you expand on this, the relationship between the ownership history and title, and maybe with an example from your practice?
Absolutely. And I think I'll give an example, really a hypothetical example that I think will be a good one. So, the ownership history and the documented ownership history of transactions and art sales, usually private art sales, but in any context, does not necessarily mean clean title. And even a very documented ownership history doesn't really mean that the possessor of that can have that legal title. And I'll get into this, particularly in the United States, and I'll talk a little bit about that in a moment. But and that's important to understand, because even if that ownership history it looks complete and it looks legitimate, that can still be illegitimate somewhere down the line. And if even one transaction, particularly in United States law, if one transaction was fraudulent, a forced sale, theft, illegal export, some misappropriation of some kind, the downstream transactions, the later transactions would be, or could be, let's say, could be invalidated, and would likely be invalidated. And remember, we were talking about this in the first series of discussions, but that the art market is famously, the private transactions, it's famously opaque in terms of transparency. And there are also multiple jurisdictions that I think we'll get into, and some of the issues with that. And so, are there exceptions to that? Of course, there are some exceptions to that. Even in U.S. law, I'll give you one quick example in U.S. law, that the voluntary provision, and we'll get into this when we talk about auction houses, but the voluntary provision to an auction house of art, of an art piece, even for a limited purpose, can lead to that auction house being able to sell that piece to a buyer in good faith, and that buyer in good faith could get title in that way. There might be a claim for fraud or for breach of contract against the art auction house, but that's a voluntary provision to that, and that's an exception that's different from theft or fraud, real fraud in some way. I think it's hard to talk about this without really raising the issue of Nazi looted art. And 80 years later, we're still talking about this because of for 12 years in a wide swath of art, some of the greatest art in the world was entirely looted or forced sales or duress sales in some way. And the important thing about that is that the title, as I was saying before, the provenance of it, the documented provenance, a lot of that was, and most of it was documented through galleries, through art dealers, through documented bills of sale, and other kinds of things that would show, if you weren't thinking about it in that way, would show potentially a clean title, but it would not. And so the line I think we used in the Chambers guide was that recorded provenance is just a history. It's not a legal guarantee. So and I think that's an important thing. I'll sort of stop there and let Kyle move on a different topic.
Yeah, well, on that topic, just to sort of
Yeah.
fill in where we are with the UK, actually, I mean, we're in precisely the same situation. Both the UK and America are both common law jurisdictions, and we both base our law and title on a series of very old sort of common law dicta, one of which is nemo dat quod non habet. You cannot give what you do not have. So just as Steve was saying, even in the UK, if at any point during that long list of transactions that you'll see in a provenance, it happens that one of the transactions was invalid because of the fact that the goods had been stolen, that could mean that the ultimate buyer will be deprived of that item and it'll be given back to the original seller. And that means, of course, that the buyer will be knocking on the door of the auction house for damages at that point. So provenance, I think, is absolutely critical to kind of managing risk within the art market, and certainly is absolutely critical within the UK art market. And something I just would like to add to that is that here in the UK, the courts are increasingly concerned about sort of collusion between buyers and sellers of art in forging provenances. There is obviously a tendency, shall we say, in some less scrupulous auction houses to overlook concerns about provenance in pursuit of high commissions. Obviously, if something does have a proper provenance, it will make it have a significantly higher value. So there's a particular case which I come across in the UK are against Greenhelg, where a forged provenance was used to sell an ancient sculpture to Bolton Museum for over £430,000. Now, researchers within the auction house, and indeed even a private contractor who was a curator in the British Museum, had basically turned a blind eye to what they thought was a rather dodgy list of transactions, which brought the item from a particular collection in the 19th century, would have been sold off in the late 19th century, down to the present. That was a particularly dodgy line of letters that had been forged, and it was pretty clear that both the British Museum curator and also the auction house had kind of deliberately turned a blind eye to their concerns there in order to get the maximum amount of money for this particular piece. So obviously the people who'd forged the provenance were themselves held guilty of fraud. But in the judgment, the judge was very, very critical of both the independent contractor who was brought in to value the piece and look at the provenance and the auction house themselves. So I think in the UK, certainly you're going to see a significant tightening on provenances, and certainly with regard to auction houses, there'll be duties that you really should not, under any circumstances, be turning a blind eye to a dodgy provenance in order to get a higher commission.
And I think we're going to get into that when we also and particularly when we get into due diligence concerns, and we get into sort of anti-money laundering and kind of where the governmental regulations are trying to catch up to that, and it's difficult. But I totally agree with you on that.
Yeah, absolutely. I think this is the overarching kind of message that should be coming out of these videos is we are very much in a transitional period in art law, from this kind of world where art was considered to be the realm of the elites, all acting among each other with a kind of informally imposed kind of structure, which was self-regulating. We're moving away from that into an acceptance of the fact that buyers in the art market are inevitably going to be consumers and need the same sort of protections they would have in the ordinary market, and that art dealers are acting in precisely the same ways and with precisely the same amounts of money as someone working in a financial institution. So the story of art law is an increasing encroachment on the art market by the law itself.
And I was just wondering about this. Both of you spoke about this relatively rigorous enforcement of, or the idea that any link in the chain could be defective, and then the whole chain is defective. Does
Hmm.
that have a depressing impact on the art market, in your view?
I'll take that. Just the thing that I would say is that I think what museums and art dealers and auction houses are starting to understand with some of the law that we'll talk about due diligence issues is that there's no guarantee here. You have to look at, and especially when we get into cross-border discussions about what was both statute of limitations and other jurisdictional issues. I think that there's no guarantee here, and you can't. It's really more of almost in some ways it's a prediction, based on what you have and the more due diligence that you have. But what's clear is that the trend is that you can't turn a blind eye. You're neither buyer nor seller. nor auction house nor art dealer.
Absolutely.
I think that's a possible trend. Yeah, go ahead.
I think picking up from that, absolutely. This is a particular problem actually for common law jurisdictions, because Steve, I think, mentioned this concept of the bona fide purchaser without notice. That is someone who has purchased a stolen item, but who had no actual knowledge that it was stolen and reasonably couldn't have known that it was actually stolen. In civil law systems in Europe, it's basically the doctrine kind of reflects the moral concerns about fairness. So in civil law European jurisdictions, if an item happens to have been stolen and then purchased by someone who didn't know about the theft, it was seen as unjust to deprive that innocent purchaser of goods when they had no way of knowing the goods were stolen, particularly where the original owners still had a right of action against the thief, or they could in themselves actually insure the things to start with. So they had actually done something wrong in not insuring them themselves. So in civil law systems, that means that they really didn't want to undermine the kind of security of the art market and the risk management of the fact that these things could be stolen in one link in the chain. And as a result, many civil law jurisdictions grant good title to someone who purchases a stolen object in good faith. By contrast, English and American common law, they both prioritize the protection of the true owner's property rights and also prioritize deterring theft. So purchasers really are put on notice that they risk losing goods unless the entire title from beginning to end and the entire provenance is kept clean. The common law also recognizes that remedies against the thief, for instance, are often illusory because thieves just disappear. And even if they haven't disappeared, it's very rare that they'll actually keep the funds that they've had from selling a piece of stolen property. So the general rule is that a purchaser of stolen property within the UK and America does not ever acquire good title. Now, that kind of difference between the common and civil law, and I'll just finish off with this, has actually created a kind of loophole which could enable strategic exploitation of those civil law rules. And we saw the potentiality of this in a case which took place here in the UK in Winkworth against Christie's. And in that particular case, a collection of Japanese artworks which was kept in London were basically stolen. The thief took them to Italy and sold them at auction in Italy to a person who was thought to be a bona fide purchaser. Under the Italian Civil Code, good faith purchasers acquire immediate title when buying from a merchant dealing in similar goods, even if the items were stolen. The collection, immediately as it was sold in Italy, was then immediately returned to London, put up in Christie's to be sold in Christie's. The original owner came into Christie's and said, "These are my items, I want them back." My title was never extinguished. And unfortunately, when this came before the court held that because they'd gone to Italy and had been sold to a bona fide purchaser, the court was obliged to apply Italian law, where the bona fide purchaser receives clean title, and therefore the original owner wasn't able to recover his goods. Now, one can see that there'd be a very small step here for a group of criminals to collude to try and create and launder those items by taking them out of the UK, selling them within a civil law system to a bona fide purchaser or someone who is apparently a bona fide purchaser, and then bringing them back to the UK and being able to sell them freely here. It is a kind of form of money laundering yet again, so there is potential for that here.
So here's a good sort of like a good example of that also, so let's just say, like, here's hypothetical. A Chagall is stolen from a private home in New York City in the 1980s. Let's place it in the Upper East Side in New York. And the just for temporal and right. And the thief moves it across the Atlantic and sells it to a reputable dealer, a completely reputable dealer in Geneva. Right. And under Swiss law and in civil law country, as Kyle was saying, generally the gallery purchases it in good faith and pays for it for value, acquires title. And let's say that art is either held by the dealer or sold, and it could be, let's say, a decade later. That artwork is sold to a London collector, buys it from the Geneva Geneva gallery, and buys the Chagall and relies on what looks to be, and this comes back to this issue of provenance versus title, looks to be an impeccable provenance record. It would look perfectly fine. Now, the caveat See, the only caveat to this is that there are things, and this is why I placed it in the 1980s. There are things like the Art Loss Register and other databases that do exist that you can check, and so perhaps that person who had the art stolen from him or her in New York City would have placed it on something like the Art Loss Register or Interpol register, right? But yeah, go ahead.
So, sorry, so this was my question to you both. I mean, this is a hair-raising scenario, to have to negotiate, navigate these different systems of law, the common law, the civil law, plus, individual, regional, national differences that come into play as well. This seems like an open door to all sorts of criminal activities going on. So I want to ask you, Steve, there must be some awareness of there must be some overarching international protections in play. Are there any multi or supra-jurisdictional frameworks do exist? What remedy is there, in fact, for somebody who finds themselves in this kind of
I say this facetiously. Clearly, at the current time, our world treaties are solid and not able to be. Anyway, I digress. But there are multinational frameworks in the art market. There are, right, and lots of caveats to that, right? So there is something called the UNESCO Convention, 1970, and it governs state-to-state interactions, right? So it governs things like illegal export or import. It requires export controls. It requires sort of like some controls and some regulations that relate to particularly state-to-state transactions, right? And that's a good thing, right? That's a good structure to have. But the thing that it doesn't do is that it doesn't reconcile the property and title issues, and it doesn't deal, and it's certainly not binding on private transactions, right? So there's lots of ways that people can get art in different kinds of ways across borders, and so there's it doesn't really regulate that private art sale, and it's particularly if there's a sale, if there's a bill of sale, that illegal export or import might not pick that up at all. So there is that. There's also something called the UNIDROIT 1995 convention, and the UNIDROIT 1995 convention. It supplements the UNESCO one. It would create, and I say would, and I'll explain why I say that. It would create civil law remedies for restitution. It would require due diligence for purchasers to be protected, and that's important. We'll get into due diligence issues, for both buyers and sellers. The caveat, and the huge caveat on this, is that very few major art market countries have adopted that one. And in fact, my understanding is that the US, UK, Switzerland, these are major art market countries, have not adopted that. And so, it exists. There are some countries that have signed on to that treaty, but it's only a factor of whether countries decide to sign on to it.
And this actually, just picking up from that, Steve, is precisely the problem, actually. I mean, throughout history, and certainly since, as I said in one of the previous videos, the British kind of invented this idea of repatriation of art. Since then, there have been a series of international conventions and international principles put in place, but all of those kind of require national states to actually enact laws within their own territory. And the problem has been, and always will be, that no state wants to enact any legislation that's going to damage the commercial art market, particularly when you're talking about countries like the United States, which has the New York art market, and obviously the UK, where we have the London art market. No one wants to put anything in place that's going to leave people feeling that there's more risk or more difficulty in selling in those two countries. And as a result of that, governments are very slow to enact protections in this particular area. And that's why, as I've said before, the art market really has become something of the last Wild West in the moving of money around the world.
I want to mention a few other sort of, generally international kinds of either regulations or guidances that can apply and are certainly relevant to talk about. So the Hague Convention, so during times of war, protects cultural property during war. It prohibits the unlawful seizure by occupying forces. And just as a side note, I started my law career as an U.S. Army prosecutor, and I would give training on both the Geneva and Hague Conventions and laws of war to soldiers that were deploying, and that was a major thing. And if you've seen the movie Monuments Men, you also understand the sort of the history of that effort. But there are a few other things that I just want to mention briefly. The ICOM, the International Council of Museums, has a code of ethics for museums that talks about sort of illegal art, fraudulent art, and restitution issues. There is in 1998 there was something called the Washington Principles for Nazi confiscated art. And that is a very important thing to talk about. That is a set of ethical principles that generally apply. And I say apply. I'll explain. There's always a caveat in the law about that. But that should and generally apply to Nazi confiscated art. And there's also something called the Terezin Declaration from 2009. But the huge that also applies to Nazi looted art and looks at towards restitution issues. The important thing to talk about with that is that these are not binding. And in fact, as recently as the Thyssen-Bornemisza case in the U.S. Supreme Court, they tried. One of the arguments was that, look, the Washington Principles says X, Y, and Z, and the problem is that those are not binding. These are guidelines, right? And so that it's sort of the international treaty, international law. They're only as good as the treaties that the countries sign on to, and ultimately you come back to the thing that I said really starting out, which is that it's the opaque art market that deals mostly in private transactions and prizes secrecy, privacy, and exclusivity amongst almost all. And that probably from the very beginning of private art sales to now, that is a consistent thread that runs through that.
Absolutely. And I think the Washington Principles are actually a really good example of what I was saying about this unwillingness to enact legislation. I mean, they had their origins in an Inter-Allied Conference in 1943, and it took from 1943 until 1998 for anything to be done. And then here in the UK, even after the Washington Principles were put in place, we didn't enact a statute kind of giving effect to what they wanted to do until 2009. There is this kind of unwillingness because you will always find a country with fewer regulations, and really the idea that you might lose your art market to that country is really, I think, putting a chilling effect on actually bringing these very stringent regulations in, and governments really are quite unwilling to do so.
On that slightly depressing note, I think we should maybe end this part of the conversation, and we will talk in our next video. We'll talk about due diligence. We will talk about the duties of gallerists, of auction houses, to ensure that we don't have this sort of weak link where then the whole chain kind of collapses.
May I just mention the statute of limitations issues as well?
Yeah. Oh yes, Steve. Yes.
Right. Yeah. I just want to talk about that briefly, and I'll try to be quick about this. But the statute of limitations problems are huge in disputes that relate to particularly cross-border and cross-jurisdictional issues. And enforcement is wildly inconsistent. And just to sort of summarize it briefly, that every country, every jurisdiction starts their clock of statute of limitations, ends their clock differently, and even measures the clock differently. And so just to give you an example, in the US, many jurisdictions in the US use something called the discovery rule. And by nature, I'm a litigator. That's how I've spent most of my career. And the discovery rule is vastly useful in terms of so for art issues, the clock doesn't start in most U.S. jurisdictions until the rightful owner discovers who has the artwork and where it is. And that means that claims could be alive for decades. But
Wow.
in civil law countries, there's often very short fixed limitations periods, and claims can expire even if the owner doesn't know the location of art and never knew it. And so it can be a perfectly timely claim in one jurisdiction. It can be too late in another, and it can be never time barred at all if you never discover where that art is in another jurisdiction. And that is a crucial issue to just perhaps end with, which is that sometimes these disputes come down to, and relates to the reason, perhaps the reason why we're giving these interviews, is that to talk about the importance of art law, is that often these disputes over where it's certainly clear that art has been stolen or looted, or in some period or another. The reality is that often these disputes, particularly for example, in that Thyssen-Bornemisza case, came down to a very hyper-technical legal issue of which jurisdiction applies and which statute of limitations applies, and which title issues apply. And that technical, hyper-technical legal issue is essentially why really the field of art law is growing and expanding, because people are understanding really more and more about the importance of these issues.
Mm.
This really seems to sort of pull against what we might understand of as natural justice. And I had a really interesting conversation with your colleague Nicholas O'Donnell on his own practice, where he was talking about very elderly people close to death who are already the children of people or the grandchildren of people who've been deprived of their property during the Nazi regime, and by technicalities and by questions such as this, prevented from seeing justice being done in their lifetimes. So it's really gives you a lot of food for thought. This.
I'll just give a kudos to Nick O'Donnell, because he's really an authority on particularly on Nazi looted art and those issues. And I've been fortunate to collaborate with him a number of times on different art law issues. And he's a great guy, and very, very, very knowledgeable. So I'm glad you got a chance to talk to him.
Thank you, and speak soon about the duties and responsibilities of gallerists and auctioneers. Thank you.